The question was, if you didn't hear it, is how much do I read into the justices' questions, suggesting that maybe there should be the right of proponents to appeal this case. Justices, good justices, ask hard questions, and before they render their decision, they want to hear the answer to the hard questions on both sides. So I took encouragement from those questions, because the answers all support our side of the case. And so we're very, very happy to have those questions asked and given us the opportunity to answer them. I don't think it tells us what the Supreme Court is doing. They will tell us when they're good and ready that what they've decided. But I am encouraged by the fact that the justices had all read the briefs, they knew the cases, they knew what the issues were, and they were asking good, intelligent, probing questions, and that's all any lawyer could ask for.
Next.
Mr.
Sorry.
Reiner, answer a question. I mean, what is so important about being here from your perspective?
What'd she say?
She asked what's so important about being here from my perspective. This is the last big piece of big puzzle piece of the civil rights movement. The gay and lesbian community is the last group of people to be discriminated against in this country, and it's long time that we accept the fact that everyone in this country should be treated equal. Everyone. And so we're here to close that last piece, the big piece, and then we are all Americans equal under the law, and that's why I'm here, to make sure that everybody's treated the same. So that's why I'm here.
And let me say this about Rob Reiner and Michelle Reiner, who is also here, and Lance Black, and Chad Griffin, and Bruce Cohen, and Ken Millman, members of the board of directors of the American Foundation for Equal Rights. I cannot begin to describe for you the amount of time, attention, and resources indefatigably that they have put forward to achieve what Rob Reiner has just described. They are doing an amazing piece of work to give us, the lawyers, the resources necessary to fight this battle. And I cannot thank Rob and Michelle and the other members of our board for the support, unstinting support, and they've been at every court hearing, every step of the way. And so I can't, as a lawyer, I can't thank our clients enough, and the four plaintiffs, of course, who have been here every step of the way, as Chad said, sacrificing themselves and their privacy in order to vindicate the rights of all Californians.
Mr. Olson, it seems that the justices were expressing concern about this being a one-sided fight if they followed your line of reasoning. If you could please clarify why you believe that's not an accurate interpretation.
Yes, I think the question was that there's some concern, and the other sides have expressed that this is a one-sided fight if we prevail on with respect to this issue concerning standing. That would not be true. Two consecutive attorneys general have come to the conclusion, and two consecutive governors have come to the conclusion that Proposition 8 is unconstitutional. These issues were presented to a district court. The proponents of Proposition 8 were present in the district court. They were allowed to put on any witnesses and to make any arguments that they wanted to make. The district court held 13 days of a trial. Witnesses were under oath. Then the district judge rendered findings and conclusions. So there is ample authority to support what the district judge has done, and our opponents have had every opportunity to present the issues. There's all kinds of briefing that's been presented. So it is far from a one-sided fight. The only one-sided part about it is that the proponents, when they were in the district court, withdrew most of their witnesses, and the rest of their witnesses supported our position that Proposition 8 was unconstitutional. So in that sense, it was a one-way fight. Our opponents didn't have a case, and the district judge recognized it.
Mr. Olson, what do you say to voters who might perceive this down here?
Oh, there you are. What are you doing hiding down there in the ground?
It's cooler.
It's the
down
only
here.
place of shade.
Yeah, exactly. What do you say to voters who might see this, if not being able to defend Prop 8 in court, the proponents of the initiative not being able to do that as overriding the will of the voters? This could have implications for all kinds of other cases and initiatives in California.
Well, the proponents were represented in court. They had every opportunity to put on the witnesses because the Attorney General and the Governor said, we don't think it's constitutional, Proposition 8, but we will enforce it. So there has to, until the judiciary decides that it's unconstitutional, we will enforce it. That required us to put on a case with evidence and witnesses and experts and testimony and that sort of thing. So Proposition 8 was fully defended to the extent that they were able actually to make credible arguments. That's where their weakness was. So the proponents have been well represented in this case, and it is not anybody's will that's being nullified except the judiciary in our country ultimately decides what is constitutional as what is not. 40 years ago, there was a law in California that prohibited people from marrying someone of a different race. That was struck down as unconstitutional by a judge, and that decision was affirmed by the United States Supreme Court. If the citizens of California had put Proposition 9 on the ballot that said, let's have that law back, where people can only marry someone of the same race, the Attorney General, I bet, in California would say, I'm not going to defend that. That's unconstitutional. That's already happened. But a judge would have to decide it again. So our system in our country gives the people the power to put something on the ballot. That's the legislative power. The officials appointed by the Constitution, the governor and the Attorney General, have the responsibility then to decide when and how to defend a measure adopted by the people. And then the judiciary in California or in the federal system decides whether their arguments are good or persuasive and whether the popular will may have invaded the right improperly of the minority. And that's what's happening here. The question is, I would be perfectly prepared, and I'm doing it here, and I've done it in various different venues. How many judges have we been before?
34.
We've been before 34 judges, so we're not afraid to put these arguments before. And every time we put these arguments out, the other side doesn't come up with much. And the other side said this was a show trial. Well, we wanted the trial to put on that evidence. The other side did not want the trial. So we're perfectly prepared to deal with opposition in this court, in any court. The problem is that the United States Constitution has certain limitations with respect to who can defend and represent issues in court. Not everyone can come off the street and do so. So as I said in court today, it's not up to us to decide. It's up to the courts to decide whether it's appropriate for our opponents at an appellate level to appear in court and file briefs, and in what capacity. We're not deciding that. We're standing here, and we've stood in front of these 34 judges, every one of them prepared to defend the fact that Proposition 8 is unfair, unreasonable, discriminatory, and unconstitutional.
Speaking of the trial, and since Ted mentioned Dustin Lance Black, who's here with us today, as well as Rob Reiner, on September 19th, there will be a Broadway premiere of a play called 8, which the Academy Award-winning writer, Lance Black, who's with us somewhere, wrote a brilliant play using the actual trial transcripts and the actual words of the brilliant attorneys, both for the intervening defendants as well as for the plaintiffs, the expert witnesses, and the judge. And that play will go live with Academy Award-winning actors on September the 19th, where major actors including Morgan Freeman, Marissa Tomei, Rob Reiner, and others will be playing the cast that have been written into the play by Lance. So I wanted to make sure that everyone was aware of that. Any other questions?
I want to make one more point.
And there's one question.
Okay,
first.
we'll have one more question. I'll make one more point. It goes to the question that was asked about whether we are anxious and willing to defend in any venue in any way what happened in the courts and Proposition 8. Just 1 week ago yesterday, in a federal district court down the street, we were attempting to encourage the district court to make the video of the trial available to all people in America, so that every one of you and every citizen in America could see what happened in that trial, and could see the evidence, and to form your own conclusions about the constitutionality of Proposition 8 and what it's doing to our fellow citizens. Our opponents don't want you to see that. They want that videotape sealed and put away in the dark someplace so that the American public can't see the evidence, can't see the record, can't see the cross-examination. Our opponents don't want to talk about this case in public. Our opponents don't want you to see the trial. We're prepared and willing to have you see the trial, to see all the evidence, and to listen and hear all of the arguments. And we're willing to do that at any time. One more last question.
Yes, I'm wondering if you could speak to the question of whether you would just as soon take this to the Supreme Court, the U.S. Supreme Court?
Well, the question was whether I would just as soon take it to the United States Supreme Court. Here's how I feel about that, and here's how we all feel about that. We set about, after Proposition 8 was enacted, taking away the rights of hundreds of thousands of Californians to enjoy the same status as the rest of Californians. We set about, along with the plaintiffs and the American Foundation for Equal Right, to strike that down, to have the courts hold it unconstitutional. If we win with respect to the standing issue and there's no appeal beyond the district court, Proposition 8 will be unconstitutional and we will have achieved the outcome. But at the same time, when we started this case, we wanted to be prepared to take it all the way to the United States Supreme Court because we're confident in the arguments that we're making, and we're confident that the United States Supreme Court will agree with us that this discrimination is wrong and must be stopped everywhere in America. So, to a certain degree, we have to follow where the courts will take us, but we're prepared to prevail at every level, at every court in the United States.
And just to emphasize that point, one final point, the American Foundation for Equal Rights has made very clear that we have a single goal and we will not stop until that goal is achieved, and that is full federal freedom to marry for every single American in this country. So I think that's a direct answer to your question.
Thank you.
Thank you.